Hello, everyone, and welcome to today's webinar, The Roadmap for Complying with the Updated FTC Safeguards Rule. Before we get started, I'd like to go over a few items so you know how to participate in today's event. When you join today's webinar, you selected to join either by phone call or computer audio. If for any reason you'd like to change your selection, you can do so by accessing the audio pane in your control panel. You'll have the opportunity to ask questions to Adam by typing your questions into the Q&A pane of the control panel. You may send in your questions at any time throughout the presentation. We'll collect them and address them at the end of today's session during the Q&A session. Today's presentation materials are available for download at any time during the session in the chat pane of your control panel. I'd now like to introduce Adam Crowell, President and General Counsel at ComplyNet.
Great. Thank you so much, Brittany, and thank you, NIADA, for having me come today to provide this presentation on this very important subject. We're going to be talking about a roadmap for complying with the updated FTC Safeguards Rule, which does have a June 9th deadline for certain provisions. So we're going to be talking about how to do that and what you need to do to get in compliance before that June 9th deadline. And there is a lot to do, so just keep that in mind. We're going to be talking about regulations. We'll have information about the regulations up on the screen at various times. Don't try to hurt your eyes reading through the entirety of the regulation. I will summarize this for you the best that I possibly can. As Brittany mentioned, my name is Adam Crowell. I'm President and General Counsel at ComplyNet. My company is a compliance and risk mitigation company. We work with thousands of dealerships across the country. We work with franchise dealers, we work with independent dealers, we work with buy here, pay here dealers, and we cover all sorts of areas of compliance, whether it be from information security standpoint, of what we call privacy and safeguards. We also focus on advertising, sales, and finance compliance, environmental health and safety, and human resources. And we have a complete compliance solution for dealers that we built out. So just as we're getting started, just a little bit more about ComplyNet here, we'll talk about, but as we're getting started, just a quick legal disclaimer. I am a licensed practicing attorney in the state of Ohio and in several federal jurisdictions. But with that said, I'm not necessarily your attorney. Do not take anything that I say here as legal advice. This is all for purposes of information only. If you do have specific legal questions, make sure that you are reaching out to your legal counsel for that. Okay, so now that I got my disclaimer out of the way, a little bit more about ComplyNet. We are a national provider for compliance services, and we are endorsed by various state associations, the NIADA, and different national providers across the country. So if you haven't heard of us before, would invite you to check us out. Go to complynet.com and learn a little bit more information about ComplyNet. We also were very much involved in helping the NIADA create what we call the FTC Safeguards Rule Playbook. That is something that is available for free to all NIADA members. And for those of you that may not be NIADA members, you can get a copy from NIADA. Please reach out to Brittany or someone else from NIADA if you'd like to get your hands on a copy of that FTC Safeguards Rule Playbook. But it does cover a lot of the things that we're going to be talking about here today. It also has different resources that are available to you. So if you don't have a copy of the FTC Safeguards Rule Playbook, you're going to want to make sure that you get your hands on that playbook. All right, so let's talk a little bit about this FTC Safeguards Rule and what it's about. And I'll tell you that the FTC Safeguards Rule has been around for a while. It was actually implemented back in 2003 or became effective in 2003. But what was happening is the FTC was seeing data breach after data breach after data breach. And the FTC, or the Federal Trade Commission, they are designed to protect consumers. And they have been empowered by the Gramm-Leach-Bliley Act to come up with different sets of rules to protect consumer information or customer information. And one of those sets of rules is the FTC Safeguards Rule. They have other rules that are out there that also are geared towards protecting consumers, things like the red flags rule, the financial privacy rule. They have the FTC's disposal rule. There's a number of rules that they use, and they even have authority under what they call their Section 5 authority, which is when they prosecute acts and practices that they consider to be unfair and deceptive. You may have heard of those as referred to as UDAP. In some states, it's in line with your Consumer Sales Practices Act or your Deceptive Trade Practices Act. But just know the FTC does have different sets of rules. We're really going to be focused on the FTC safeguards rule today. But the one thing I do want to mention, and I think this is important for you to know, is that the FTC also uses that authority for what they consider to be unfair and deceptive acts and practices to also go after businesses that are suffering data breaches. And essentially what they're doing in these cases is they're looking at the processes that were in place and the procedures and the different protections, the safeguards essentially that are in place at these businesses. And when they're suffering data breaches, they're basically saying, hey, you should have been doing this, you should have been doing that. There was an expectation that you would have those types of things in place. You may have even had a privacy policy on your website that says that you're going to be protecting information, but they're using that authority to go after businesses. So even though I'm talking about this rule where there's certain provisions that already went into effect and there's other provisions that are going into effect on June the 9th, just know that the FTC has other power to potentially come after your business and to basically submit penalties and fines and violations if they think that you weren't doing enough from an information security standpoint. So just going back to the FTC safeguards rule itself, as I mentioned, it first took effect in 2003. There were data breaches that were happening. When the FTC takes these enforcement actions, they will generally have a consent order or some sort of stipulated entry or a judgment that they're submitting to the court. And essentially, there's certain requirements that are being put in place when they're taking these actions. And they've taken these actions against some very large businesses, companies like Equifax, Dealer Built. There's been a number of other ones that they've gone after. In fact, they've gone after a few different companies just here in the past several months when it came to security practices. But they kept building into these things that there were certain things that the businesses needed to do to protect the customer information. And the way that the original safeguards rule was designed, it was a little bit more flexible. It was a little more vague. But now there are some very definitive requirements that have really been built into this. And so in October 2021, they announced the new FTC safeguards rule. Certain provisions, basically the same provisions that were already in place, took effect on January the 10th of 2022 under the new rule. So they kind of kept all the things that were required before. But there were certain provisions that they said had to go into effect and be implemented by December the 9th of 2022. Due to requests by different associations to extend that date, different associations, dealer associations, small business association, others, the FTC has extended the deadline for some of these requirements to the June the 9th deadline. And I'm going to talk to you about all the different requirements and those things that are now required for June the 9th. But understand that the FTC has some pretty significant penalties. They can level up to $50,000, $120 per violation. And this could potentially be per customer record. And so when you start to think about how much information that you're keeping at your dealership or in your dealership systems, that could be a lot of information, and those could be some very, very hefty fines. The one thing I do want to say about this FTC safeguards rule is it is designed to relate to businesses that are considered to be financial institutions. There is a very broad definition of what a financial institution is. However, it could be simply a business that helps or assists in obtaining credit for consumers. So your dealership which is regularly involved in credit in one way, shape, or form, would fall under that definition of a financial institution. So this is designed to provide basically the same requirements that a bank or a lender also has when it comes to protecting information. And so the requirements are very definitive here, and it really relates to the information that's received or obtained for the potential purpose or for the purpose of getting a financial service. But in all reality, we all know that all the information is commingled. So whether you're doing service or not, or just selling vehicles, or if it's a cash deal versus finance deal, it doesn't really matter. It's all going in the CRM. It's all going in the same file room. And the FTC, once again, has that authority to prosecute unfair and deceptive acts and practices in the security realm against pretty much all businesses. So what I like to tell people is, yeah, this is designed for certain transactions and for certain businesses essentially, but in reality, every single one of these provisions will apply in one way, shape, or form, whether it's under this act or another act, for pretty much all of the customer information that you're obtaining. And when you think about the customer information that you have, it's really geared towards non-public personal information. And when we're talking about this non-public information, it could be simply the fact that they're your customer, okay? So just a name that's being disclosed to some third party unauthorized. It's about protecting that type of information. So it doesn't necessarily just have to be things that are super sensitive, like a social security number or a bank account information or date of birth. I mean, it could just simply be that person's name and their email address. And when you think about your dealership and you think about these other financial institutions, you have a treasure trove of information that these identity thieves want, because they could take that information from a credit application loan and turn that into a good living from an identity theft standpoint. So the regulation itself is pretty lengthy. It's a lot to read through, but we've identified 10 steps for compliance with this new rule. And I'm going to set forth each one of these for you individually. And you'll see on the screen, I'll show you the regulation. So anyone that wants a copy of the slide deck, you can reach out to me afterwards. I'll provide a copy to you. I think that Brittany also put it in the chat feature, so you can get a copy of the slide deck from the chat feature. But I wanted to have the rule there and available to you, so if you want to read through it, you could. So like I said, I'm going to go through these, but I'm going to summarize these for you so you understand it. So the very first step in this process is to put together the right team, okay? And at the end of the process, it's going to be about creating an annual report that goes to your top brass, okay? I said a report to the board, but it could be to your partners, it could be to, some other governing body, or if you don't have any of those, it's basically the top executives for your dealership. But the reason why the FTC designed this program to be this way is because they wanted to have accountability. They wanted to have someone that was in charge of the program, that was basically getting the authority from the top decision makers. And then that way, if there's anything that goes sideways, they could point to either that qualified individual or to the top executives at the company and say, okay, it's your fault. And by the way, when the FTC has taken enforcement actions over the past year, and they do go after dealers for various things, there have been cases where they're actually going after a general manager, or they're going after a vice president in one case too. So you've seen some multi-million-dollar settlements that have come out where they've also had personal liability that's been attached to general managers and to top executives for dealerships. So just thought I'd mention that. So let's start with step number one, establishing the safeguards team. Okay, the rule itself talks about how you need to have a written information security program. And as part of this information security program, you need to have someone that's in charge of the program, which they are now calling a qualified individual. This qualified individual has to implement, oversee, and enforce the program. In the comments to the rule when it got passed, the FTC said, however, that this qualified individual does not need to have any particular qualifications or education or experience. They don't need a certification, for example. They just need to be savvy enough to understand this program and be able to implement, oversee, and enforce it. But the rule also does require that you utilize qualified information security personnel that are going to help oversee and enforce the program too, okay? So this is where you're going to need to work with IT, whether it's in-house or most of you are probably having some third party that's helping you out with it. But it really shouldn't just be the person that knows the most about computers at your dealership. You really need to work with an IT resource to help you, because there are technical requirements here, and you're going to need that IT resource. This rule, by the way, is designed to change the way that you do business, and it is going to require that you spend some money to get into compliance. And if you don't, and there is a data breach or there's some other thing that comes up where the information wasn't being properly protected, the FTC will in fact come after your dealership if it gets to them, or it's going to be an attorney general. Sometimes the FTC works with the attorney generals to also go after businesses, and we've been seeing that trend increasing over the past few years. So understand that you need to have a qualified individual. And I usually suggest that be someone at your dealership, because if you need someone to implement, oversee, and enforce, how are they going to do that if they don't have any real authority to do so? Of course, the rule says that if it is a third party, you still need to have someone that's in charge at your dealership or your location, your facility, to also oversee that person. But the key here is to make sure that you have someone that's in charge, that has the power and authority to do so, and the backing of your team to do it. And you're going to have to work with qualified information security personnel or IT to move this program along. So essentially, I'll tell you a little bit about how we do it, and it'll kind of give you a little bit of an idea. But what we always do is we always have someone that's designated from the dealership to be a qualified individual. We also identify who their IT resource is. If they don't have an IT resource, we help them find one and put one in place. And then we also have our compliance specialists that's helping guide people through this process. They're called our compliance success managers. But the idea behind the safeguards team is to make sure that they're meeting on a regular basis. They're making sure that they all have certain roles and responsibilities, and that everything is trending in the right direction. Because as I mentioned before, there's a buildup to that annual report that is going to the top brass. But the idea is to make sure that they're tracking the progress, resolving issues, and ultimately creating that annual report that goes to the board. So that's step one, is establishing the safeguards team. Step number two is conducting a risk assessment. And there's going to be an initial risk assessment, but there's also going to be periodic risk assessments that are happening. And as part of this risk assessment process, what you need to do is you need to start identifying where customer information is residing, who has access to that customer information, on what devices, on what programs, okay? And this could be your employees, it could be third parties, it could be vendors, but you're trying to map out where this information is being stored, because then what you have to do is you have to start looking at what sort of safeguards do you have in place to protect the information so it's not being disclosed unauthorized to third parties, where there could be some sort of data breach, or even to a third party that you're authorized, but making sure that they're protecting the information the way that they do. So what you want to do here is you want to go through and you want to map that information. You want to identify the risks. You want to evaluate and categorize the risks. You want to examine various controls and safeguards. You also want to look at ways that you can, out of the gate, start to mitigate those risks, or even accept or address some of those risks that are there. And then you need to periodically re-examine the controls and safeguards. Of course, one of the things that we do is we will send out electronic risk assessments that are documented to the qualified individual, but also to employees, and trying to gather information and try to figure out ways that information is being protected, or maybe there's some other issue that's going on. People are sharing credentials when they shouldn't be, and so on and so forth. So that's step number two, is to make sure that you're conducting risk assessments, and they're documented. They have to be written risk assessments. Electronically documented would count as a written risk assessment. Third, you need to have a written information security program. And I mentioned that at the very beginning, but you have to go through the risk assessment process first in developing this written information security program. And the idea behind this written information security program is to identify the various safeguards that you're going to put in place to make sure that the customer information is being protected. And it's supposed to cover administrative safeguards, physical safeguards, and technical safeguards. So you're going to cover all those, and it's going to identify clear roles and responsibilities. Of course, the person that's going to be in charge of this information security program is a qualified individual. So the qualified individual is going to have quite a bit of roles and responsibilities in this, but you need to make sure that this information security program is custom tailored to your dealership in the way that your dealership does business. It should be clear and concise, and it needs to be periodically evaluated and adjusted. And that's really going to be part of that annual reporting process on top of that. So that's step number 3. The one thing that I will say about that is I mentioned the FTC Safeguards Rule Playbook at the beginning of this. Just know as an appendix to that FTC Safeguards Rule Playbook, there is a template for an information security program. Okay, but if you were to utilize that, for example, there's going to be other policies and procedures that you're going to need to put in place. That information security program is citing to, and you might already have some of those things in place at your dealership. Maybe you have some sort of acceptable use policy when it comes to technology, or you have a data and document retention schedule that's up to date, or you have a clean desk and clean screen sort of policy. Just know that you should have your information security program also identifying those various policies that you put in place to protect this customer information. So step number 4 is information security training. Under the previous rule, it suggested that financial institutions, including dealerships, put this type of training together for their employees and their workers, so they understood the importance of protecting the information and how to recognize bad things like phishing attacks. But now the rule definitively requires and makes it mandatory that you provide information security awareness training to your employees. So anyone that has this type of access to customer information. And there's various types of trainings that you should be providing. Of course, we provide as part of our platform these various types of trainings, but things like privacy and safeguards, privacy for the shop, disposal, so how to properly dispose of information. By the way, that also relates to the FTC's disposal rule that I mentioned earlier. There should be things like information security awareness training, phishing, and then there should also be things like PCI compliance when it relates to how you're handling credit card information. There are certain requirements as it relates to those with those credit card processors too. So make sure that you're providing that sort of training. And then of course the training should be based upon, the job role and what sort of access that people have. So if they're not handling the credit cards, for example, they don't need to have the PCI sort of training. All right. So another thing that the FTC talks about, so this isn't spelled out in the exact rule itself, but the rule does talk about testing key systems. And I would argue at every single dealership, one of your key systems is your email system, because you have a lot of employees that are interacting with all sorts of customers across those email systems. But the FTC commentary does talk about phishing and talks about these simulated phishing attacks, or what they're also referring to as phishing penetration testing. So they consider phishing to be a form of penetration testing of employees. It's not a penetration test of a system, but it's basically a test to try to see who will potentially fall prey to a phishing attack. And they talk about how that is key for preparing for, getting in compliance with, a safeguard sort of program. So they talk about the importance of doing the phishing. And I would argue that you absolutely should be doing phishing penetration testing or simulated phishing attacks with employees, because that's your number one risk at your dealership. 91% of all hacking starts with phishing. I'll tell you, just yesterday, I was checking my personal email, and I saw something from a hardware store saying that I won 170 tools. But when I went to go look at the actual email address that it was coming from, it clearly was not coming from the hardware store. It was a phishing attack. They were trying to get me to either click on a link, download information, or potentially give away credentials. And all those things are very, very dangerous, of course. So you should be conducting this phishing penetration testing, because after all, it's also going to tell you how well people took to the phishing penetration or the phishing testing or training that you were providing to them earlier. So go through this process. And we have all sorts of different statistics on this. There are other parties or third parties that have information on this too statistically, but the average number of people that will fall for phishing attacks starts out north of 30%. Once you start providing effective phishing training to them, that number significantly drops. It drops below 3%. So it is absolutely imperative that you go through this process of training your employees and also testing them with this type of phishing simulated attack to make sure that they're not falling prey, because it could just be simply clicking on an unsubscribe link, and that unsubscribe link will also download some sort of malware or allow someone to remote into the computer all of a sudden. There's all sorts of scary things that I've seen where, just by clicking on a link, now all of a sudden someone's remotely into your computer. So you need to provide that type of training and need to make sure that it's effective. All right, so here's another very important aspect to the safeguards rule. It's not just about your dealership, it's also about all your vendors that also have access to the customer information. So start thinking about that. Think about where this information is residing and who has access to it, and understand that you do have obligations. You have an obligation to select service providers that are capable of maintaining the appropriate safeguards, and you're required to assess them to make sure that they're able to have the appropriate safeguards. So think about how you would do that. You could potentially go to every single one of your vendors, ask them what their security practices are, send us some sort of form to them, have them fill it out, and that would be part of the process. But you're also required for any of your vendors that have access to this customer information to contractually obligate them to protect the information. So maybe you have a master services agreement with them. Maybe it talks about the Gramm-Leach-Bliley Act or the FTC safeguards rule and the things that they're going to do to protect it. And that's great. But if you don't, you're going to have to send them off addendums or various things to try to make sure that they're contractually obligated to protect the information. And the FTC in their commentary has said that if you have a service provider that's not cooperating, so maybe they're not telling you what their security practices are, they're not completing an assessment, they're not being contractually obligated, or they're refusing, the FTC has said that you need to consider working with other service providers, okay? And there are a number of other service providers in the auto industry. There's all sorts of service providers in the auto industry. And you might like the one that you have, but if they're not going to cooperate with you, the FTC basically says, if they're not going to do the things that they're supposed to, you need to look for somebody else. All right. So one of the things that we do to try to help our dealers, and just a way to think about it, but from a systematic standpoint, we will actually send out assessments to various service providers. We will have them complete those assessments, and we have that set to reoccur periodically. But the idea behind that is once we get an assessment done for a vendor, then it can be available to anyone that also is working with us. And we do the same thing with the agreement. So if someone has completed an assessment, they also have the opportunity to complete an agreement that's agreeing to protect the information. So that way it covers anyone that might potentially be working with us. So we do it from an automatic sort of standpoint where it's sending out through emails, it will send reminders and those sort of things, but you can also try to send those out, through the mail or through other methods such as email to make sure that you're also getting that information yourself. All right, so the seventh step deals with your access controls, okay? And think about this as all the things that you're doing from both a physical and technical standpoint to make sure that people only have the type of access that they need, okay? And so there's a number of things that are mentioned in the rules about these various safeguards, but think about things like change management procedures. And when I talk about change management procedures, we're talking about things like what's your onboarding process, what's your offboarding process. When you're hiring somebody, what sort of processes do you have in place to make sure that they're only getting access to the programs that they need, and whatever access has been granted is really limited to what they really need to get access to. What sort of devices are they being provided with? How are they communicating with customers? Is it using a program that you have, or is it a personal cell phone, or are they using their own Gmail, or how's that all operating? But you need to have the proper access controls in place. And I'll tell you right now, if you have employees that are using their own emails, that's got to be a practice that you stop. And if you have people that are also getting things like text messages that are giving them things like credit applications and things like that, you need to stop that practice too. You need to start looking at whether or not you can do that through your CRM system or some other secure system to make sure that they're getting that information. There's always going to be some level of information that's going to be coming in, but especially when you're dealing with some of that really, really sensitive information, you don't want it living in someone else's email system or someone else's device, because if they leave you, you're never going to be able to claw that back. And what are they going to potentially do with it later on down the road? That's the type of stuff that you can get in trouble. The other thing that, from an access control standpoint that's mentioned is that you need to have a data and document retention and disposal policy that's put in place. And what the FTC specifically says is that when you are no longer using that information, you have to get rid of it within at least 2 years, okay? But what I'll tell you is pretty much every single document that you're collecting, you need to keep for longer than a 2-year period, okay? So, for example, let's say that you have a credit application, it becomes a dead credit application. In those situations, you have certain requirements under either the FCRA, the Fair Credit Reporting Act, or the Equal Credit Opportunity Act. One of those requires that you actually keep it for a 25-month period. Okay, so you have an absolute record retention requirement that's now exceeded the 25-month or 24 months. It's now 25 months. But if a consumer were later to come down the road and say, hey, there was some sort of discriminatory conduct that was happening, you'd want to have your records available to you to show that you were actually doing all the right things. And they have up to 5 years to take action against you. So when you think about how long you should be keeping records, it's usually a mixture of multiple things. It's actual record retention requirements. It sometimes is regulator look back periods for audits. So think about like the IRS and others, and sometimes it's a mixture of statute of limitations, statute of repose, and some best business practices that are out there too. So if you work with a law firm or you work with an accounting firm, you might have some different record retention schedules that have been sent out to you. Of course, most of the accounting firms will tell you that for pretty much any documentation that you've received that somehow supports your income, they're going to tell you to keep it for at least 7 years. Some attorneys might actually tell you to keep it for a longer period of time. But this is why it's really important to make sure that you're documenting what your schedule is, and then you're actually following it. So if you're saying that, hey, for these particular documents, at a certain point, we're going to take care of those and we're going to destroy them, you do have to destroy them in such a way where they can't be reread later on down the road. Now, there's, of course, always exceptions to different things. Maybe you're in a litigation case or something like that, and your lawyers are telling you that you have to keep them longer, and that's fine. In fact, you're legally required sometimes to keep those records, but that's where you're going to have to work with your legal counsel to go through that. But you also need to make sure that you have, different processes and procedures in place, and that you're also making sure that when it comes to who's using the information, it's being properly documented, things aren't being shared, so on and so forth. So there's no unauthorized access that's ultimately happening. So once again, you want to grant limited access. You're also going to need to monitor and log activity. Most programs do have built-in audit trails of what people might be looking at. And this becomes particularly important if there is in fact a data breach that were to occur. So then you can potentially see what a user might have been accessing and what they would have downloaded and given to third parties or so on and so forth. But you need to think about this from a physical standpoint side too. Do you have, for example, a file room, or do you have, a locked filing cabinet? Who's checking in and out information? How are you documenting that? Kind of think of that as like checking a book in and out of the library. Where is it being documented? Maybe it's being documented on the deal jacket itself, but you should have those processes and procedures put in place. You should make sure that you're dialing in your onboarding and offboarding processes. One of the things that you should think about is who's your system administrator for all your various programs. Is it one person or is it multiple people? Because maybe sometimes people aren't on the same page about what should be granted, what shouldn't, when should it be taken away, so on and so forth. I've seen cases where someone leaves a dealership and it's later discovered that person's been, went to some other dealership and they've been accessing the CRM, 400 times over a period of a year. In those types of cases, that former employee definitely did something wrong. They never should have been in that system, but the original dealership should have shut off the access as soon as that person left too. And then of course the data and document retention is a big part of this too. All right, so now I'm going to get into the really fun technical requirements that are on here too. And once again, I mentioned the point of this regulation is to change the way that you do business. And so they are now requiring that for any information system, so any system that has customer information, essentially, that you need to put in place things like multi-factor authentication. Okay, so that would be where you try to log into the system and it sends you a text message or it sends some code to your email, but some level of multi-factor authentication for these systems. It's also requiring that those systems be encrypted. And the FTC has had different cases over the past year about encryption and what counts as encryption or weak encryption and so on and so forth, but there needs to be strongly encrypted systems. It is also requiring for these information systems that you conduct continuous monitoring of those systems, or absent effective continuous monitoring, penetration testing at least annually, or vulnerability scanning at least every 2 months. Okay, and I'm going to explain what those are to you, but I will tell you this, that the FTC has rained down on different businesses in the past. And when they've required things like penetration testing, what they're talking about there is they're talking about having someone that is a cybersecurity expert. They usually have some level of certification. They've been in the industry for at least 5 years, but these are people that are trying to hack in your system, and they might be using different tools and things to do it, but they also might just be calling someone up on the phone and trying to get through it. So let me explain what these different things are really, really quickly. I talked a little bit about the penetration testing, but think about a vulnerability scan is kind of like looking at your networks or looking at your dealership, right? And if I look at your dealership and I see a window, I see a door, those are potential access points that I know to be able to get into it. Just like if they're looking at your networks and they see a port that's open, okay, that's a potential way that I can get in the system and I can get information. So this is one of the things that you have to start thinking about is, okay, am I going to start doing vulnerability scans? Because I have to either do the continuous monitoring or I have to do the penetration testing and vulnerability scans. The penetration testing, of course, is looking at that property and saying, how am I going to get into it? Okay, and I went through that vulnerability scan process and I understand that, but now let me see if I can actually get inside and how far can I go? So can I go up to the door and open it, or can I just try to kick it down and break into it? And then once I'm inside, where can I go? What sort of access can I get to? And that's where these ethical hackers would come in and try to break into your systems and go through that. Once again, that's pretty expensive because it's somewhat of a manual process with people that are highly qualified to do it, which is why I tend to suggest that you look at continuous monitoring, because continuous monitoring is that 24/7, 365 sort of, scanning of your system, seeing what's happening, and then alerting someone when there's some sort of suspicious activity that is in fact going on. Think of that as like having security at your dealership, and they can see something that's coming, or they can start to lock down the premises once there's some sort of breach of your property that happens, or your networks in this case. It used to be that continuous monitoring was very expensive. It's become more productized now over the years. Some of you may have heard of this as referred to as endpoint detection and response, but that's the type of continuous monitoring that you need to have in place. All right, so the ninth and the next to last requirement is to have a written incident response plan. And just to summarize this for you really, really quickly, is you need to have basically a plan in place for security events, okay? You need to be able to detect, respond, recover, remediate, and revise your information security program to make sure that these types of things don't happen again if there is an incident. So that's the whole purpose behind having a written incident response plan. So you have a game plan together to really understand what you need to do next. And as I mentioned with that FTC Safeguards Rule Playbook, there is a template for a written information security program. There is also a template for a written incident response plan that goes along with that too. All right, so the last requirement is this annual report. So as I mentioned to you, there's the requirement that starts at the beginning, putting together a safeguards team, but that qualified individual that's part of that safeguards team is going to be putting together a written information or a written report to the board, okay? And it talks about having a board of directors. And if you don't have a board of directors, it's an equivalent governing body. And if you don't have either one of those, it's going to be a report to the most senior officer that's responsible for the information security program. Okay, so it doesn't matter how you're set up. If you're set up as a corporation or a LLC or a partnership, or you're a sole proprietor, basically the idea behind this is to get that report to you, so you can understand what's going on with the information security program. And it's going to go over overall compliance with the FTC safeguards rule and material matters related to the information security program. So it wants to know what sort of risks have been assessed, how have these risks been managed and controlled, what are the service provider arrangements, what are the results of testing, have there been any security violations, events, and responses. And that could be as brutal as a data breach, but it also could be just the fact that someone was in files when they shouldn't have been. And then also it needs to cover any sort of proposed changes. So this is where the qualified individual would say to the leadership team, say, okay, these are the types of things that we found. Here are ways that we think that we can improve. And here's what I would suggest that we do to change this going forward. Hey, I need some additional funds to be able to pay for this, so on and so forth. So that has to be a written annual report. And keep in mind, the FTC with this new rule now, they can come to a dealership if they wanted to ask for this type of information. And if it turns out that you don't have the annual report, you don't have a written information security program, you don't have these other things that are put in place, they could have fines, even if there wasn't a data breach that ultimately happened. So keep in mind that these are all the requirements. Now, with that said, I am going to tell you about a limited exception for some provisions of this new rule, okay? And here's what the limited exceptions are. And I'm going to have a lot of information up on the screen here, but this limited exception only applies to dealers that have less than 5,000 customer records, okay? And when I'm talking about customer records, I'm talking about records related to, some sort of financial sort of transaction. Okay. But this has to do with customer records of less than 5,000. And that's not 5,000 that you collected in a month, in a year. This is the number of records that you've collected over a lifetime. Okay. It could be literally a list that's provided to you from a marketing company saying, here's potential clients or people that might be interested in financing a vehicle. That list alone could put you over the 5,000 mark. So just keep that in mind. And I always give that warning because some people get their hopes up and say, oh, well, there's certain things that I don't have to do now, or I don't have to do it all. And none of that stuff is true, especially when you consider that it's very easy to surpass that 5,000 records. So here's the limited exception. And I kind of broke it out on the left and on the right in a couple different ways, but I took you through those 10 steps previously, okay? And the things that are in red on the right-hand side are the things that you wouldn't have to do if you had less than the 5,000 consumer records, okay? You would still need to have a safeguards team, and you'd still need to do a risk assessment and periodic risk assessments, but those risk assessments would not have to be in writing, okay? You would still have to have a written information security program. You would still have to provide the security awareness trainings. You would still have to do the phishing penetration testing. You would still have to do the service provider assessments and agreements. You would still have to have the different access controls that we talked about, and the various technical requirements that we talked about, with the exception of the continuous monitoring, penetration testing, or vulnerability scanning. And you wouldn't have to have a written incident response plan or a written status report that's being generated at least annually, okay? But once again, be very, very careful if you think that you qualify for that, and please reach out to someone like me to talk about this if you think that you're under that 5,000 mark, because when you start thinking about all the information that you're warehousing in your CRM, your DMS, and credit applications and deal jackets, in your emails, maybe social media, the website, think about all that information that you're collecting. It's very, very easy to surpass that 5,000 consumer records. And even if you are into that 5,000 mark, don't think that that lets you off the hook. There's still a ton of stuff to do, even if you do, in fact, qualify for that limited exception. So with that said, I'm going to now open this up for questions. I did want to remind you once again that there is that FTC Safeguards Rule Playbook with those various templates that are attached to that as an appendix, and that's a resource for you. But I would like to go ahead and open this up for questions at this time.
Thanks, Adam. We're going to go ahead and begin the Q&A. As a reminder, all of our attendees can submit questions through the Q&A panel at the bottom of your control panel. So our first question is, how does this rule relate to cyber insurance requirements?
Oh, that's a great, really great question. Thank you so much. So as it relates to cyber insurance, I don't know, number one, if you don't have cyber insurance in this day and age, you're making a big mistake. You need to get cyber insurance. For those of you that have had cyber insurance and have recently gone through a renewal in the past couple of years, you probably have noticed that the cyber insurance application has doubled in size. It went from about a page and a half to about 4 full pages now at this point. And that's with different providers. And the reason why I heard that has happened is because in 2020 alone, there are certain reinsurance companies. There's about 10 reinsurance companies out there as it relates to this cyber insurance, and they collected about $7 billion in premiums. But guess what? They paid out about $20 billion in claims. So they don't want to be in the business to lose money. So what are they doing now? They are now having additional requirements that are being put upon their insureds to make sure that they're a better risk. Okay, so they were paying out a lot of ransomware claims and things like that, or there was a data breach, and all of a sudden now it's a big class action. There's notifications that have to happen, and so on and so forth. But they're now requiring that pretty much all the stuff that we talked about before, that you do all of it. Okay, in addition to other things like making sure that you have secure backups and things like that too, so you can recover all of your data. So I talk about this rule and all these requirements of this rule, but the cyber insurance companies are also requiring that you do all this stuff too, in addition to some other things on top of that. So you have to keep that in mind. And maybe you fill out an application and say, yeah, we're doing this stuff, but you're really not doing this stuff. Well, just keep in mind the cyber insurance companies, even if they grant you the coverage, or they're collecting the premium from you, if it turns out that the information that you gave on to them on that application wasn't correct, and you didn't have all the things in place that you say that you had in place, they can flat deny the coverage. And in fact, sometimes they'll actually file actions. And I've seen this happen over the past year where they filed actions in court asking the court to declare that there's no coverage because the insureds weren't doing all the things that they said that they would in the application.
Awesome. Our next question is, I own a buy here, pay here lot, but we don't run our customers' credit. Does that mean that we're not a financial institution?
You're absolutely a financial institution. And not only are you regulated by the FTC, but you're also regulated by the CFPB. So even though you're not running their credit, it doesn't really matter. It's the fact that you have customer information, and you are, in fact, you're more of a financial institution than someone that's not doing buy here, pay here, because you're actually extending them the credit. So this rule squarely applies to buy here, pay here dealers too.
All right. Our next question is, do I need to conduct continuous monitoring, penetration testing, and vulnerability scanning?
Yeah, so just once again, you have an option of doing one or the other, or if you want, you can do both. So you can do continuous monitoring, or you can do the penetration testing that's annual and the vulnerability scanning that's at least every 6 months. If you want to do all three, you can, but the rule basically says you can either do the continuous monitoring or the other two.
Okay. And the next one is actually regards to repossession. So when placing a contract out for repossession, are we limited as far as how much information we can provide to a repossession vendor?
Great question. So keep in mind, with any of your service providers, you have to make sure that they're basically going through all of the same things that you're going through. So when they're talking about selecting service providers that are capable of maintaining the appropriate safeguards, they mean that if they have systems that they're doing continuous monitoring, that they're having the multi-factor authentication, that they have the proper access controls, that they're providing their employees with trainings and all that stuff. So even when you're just selecting one of these providers, even a repo company, you need to make sure that they're doing the things that you're also doing, and that you're contractually requiring them to protect the information. And you absolutely should be limiting the information that you're providing to them. So you don't want to give them, for example, the entirety of the deal jacket. You want to give them the information that is necessary for them to do the job, but you also need to make sure that they're going to protect the information, and that they're also going to, have the proper procedures in place to safely protect the information that you provided to them.
And this next one, I think, ties in a little bit with the answer you just gave, but it's regarding vendor compliance. Do we need to ensure lending partners are compliant, or are they already compliant as they've been subject to these safeguard rules for many years?
Great question. So you do have to make sure that they're compliant. They have, in fact, been subject to the safeguards rule for many years. I will tell you that many of them are still working on getting compliance with the new updated standard. But yes, you should be asking even the lending institutions that you're working with, do you have these types of procedures in place? Maybe they'll even provide you with a sheet that tells you what their security practices are, but you should be asking them for that information, and you should be contractually obligating them to protect that information.
All right. And our last question, do you have IT companies that you would recommend?
Yeah, so we're pretty agnostic of who we work with. We work with different IT companies across the nation. We don't attempt to be the IT firm We're a compliance company. We're not an IT firm. If you need someone from an IT standpoint, there are various companies that we could recommend to you. Some of it, maybe it's based on region, but there are a number of IT firms out there that can help with some of these technical requirements that are necessary and be involved in that process. But you absolutely need to have someone from an IT standpoint that's involved in this program.
Okay. And I actually lied. We just had 2 more questions come in. So if my sales guys contact the customer by text, do you have an app to recommend?
Yeah, so I would really recommend that any sort of interaction that's happening with the customers, that it happens directly through the CRM, and that everything's being in the CRM, and that anything else is being deleted out after it's put into the CRM. So having everything flow into your CRM would be the best way to go with anything along those lines. And if you don't have a CRM, then you're going to have to look for other alternatives. But most dealerships are using their CRM to manage that process right now.
All right, fantastic. And the next one is actually a question for me. So it's about rewatching the session. You will receive a recording of this session within 24 to 48 hours that you can watch at your convenience as an on-demand session. So that actually wraps up our Q&A for today. So thank you so much, Adam, for the information. Thank you, everyone, for attending the webinar. You will receive a survey on the presentation. We really would appreciate your feedback as soon as you leave this session. And on behalf of ComplyNet and NIADA, thank you for joining us today, and have a great rest of your day.
Yeah, and everyone, thank you very much for attending today. If you do have any questions, feel free to reach out to me directly. My email address is adam.crowell@complynet.com. You can also go to complynet.com, and we have places where you can meet with us, basically schedule a demo or a discussion with us, so you can go over what the safeguards rule requirements and how we can help with that. We do have different programs that we put together. We have a compliance management system that really tracks compliance with this particular rule. So we have things for privacy and safeguards. We have a program for sales, finance, and advertising that also focuses on the key aspects. And that for those of you that have a service department, we also have a program for environmental health and safety that is very similar, and it's tracking all the necessary KPIs when it's coming to be compliant, and truly a complete compliance solution. So for anyone that wants to, for example, have a meeting with us, there's a QR code, or you can go to complynet.com/meet-with-us.
All right, fantastic. Thank you so much, everyone, and have a great rest of your day.
Great. Thank you, everyone.